this afternoon's presentation. The topic of the presentation is aged care industry, the changing IR landscape, recent reforms. My name is Duggan. I head up the employment team here at Duggan Lawyers. I'm delighted to be able to give this presentation to you this afternoon. By way of background, the ALP had a significant workplace reform policy that it took to the last election. And promised a more expansionist role for the federal government. It's greater regulation under policy. The greater regulation was designed to achieve some key goals that included higher wages through changes to enterprise bargaining rules, greater regulation of insecure work, including casual employment, and closing pay gender gap. In late 2022, Labor, with the support of the Greens, was able to pass its bill to amend the Fair Work laws known as the Secure Jobs Better Pay, and that was the first tranche of 3 reforms that it's able to pass through federal parliament. The other 2 tranches were under the Closing Loopholes Bill. Key aspects of that included more changes to enterprise bargaining rules, greater rights for union delegates and officials, further regulation of insecure work, and changes to workplace compliance. That bill, of course, was split into 2, with the first passed late last year and the second part of it passed earlier this year. These reforms under these 3 tranches are the most significant permanent changes to the federal conductor relations system since the introduction of the Fair Work laws back in 2010. My focus today will be on the most recent of these reforms, namely those contained under the Closing Loopholes Bill, and these have, of course, the greatest impact upon the aged care industry and employers more generally in the country. I'll go through this in a thematic approach, talking about the different topics that have been changed through the reforms. The first topic I wanted to touch upon was in relation to the union governance. The union movement continues to maintain its influence despite a steady decline in union density in Australia. Labor's Closing Loopholes reforms have, despite this trend, expanded and introduced new union rights. The main union right that existed prior to the reforms under the Fair Work laws was right of entry rights, and they were available to union officials being a paid staff member of the union. Right of entry rights enabled officials the right to enter workplaces for a safety reason, the discussion purpose, or an investigation. And then other requirements in relation to those right of entry rights. Closing loopholes have expanded these rights, in particular to enable an official to attend a workplace to assist a workplace safety representative. The key aspect of the reforms in this area is the introduction of explicit rights for workplace delegates, and this occurred from late last year. Workplace delegates did not, unlike union officials, have explicit rights under the Fair Work laws before these reforms. And when I'm talking about a workplace delegate, what we're really talking about is an employee of your business that has been appointed by a union to represent their members, somebody who might have been referred to as a shop steward in days gone by. Specifically, workplace delegates will now have various rights under the law. They include a right to communicate, that is, to communicate with members and potential members about their industrial interests, and access, that is, reasonable access to the workplace and workplace facilities where the business is operated, and training, that is, reasonable access to paid workplace delegate training. There's an exception of that in relation to small business. The practical effect of these rights is that a workplace delegate can now spend their time, their work time, that is, exercising these rights, for instance, to attend training rather than working. In practice, an employer must afford a workplace delegate these rights which comes at the obvious cost of the business of productivity. That's a right that appears under the Fair Work laws. Separate to that, industrial instruments, that is, agreements or awards, must also provide for a workplace delegate rights term. So all modern awards and new enterprise agreements must include a workplace delegate rights term from the 1st of July. So if any of you are in the process of negotiating an enterprise agreement at this point, you'll need to ensure that you include a workplace delegate rights term in that enterprise agreement. The other area where there has been significant change is in the area of regulation. And this has, in my opinion, the most attractive effect on the industry as well as employers throughout the country. So a particular focus of Labor's IR policy that it took after the election was great labour regulation. And the explicit target of this regulation was 3 labour models utilised regularly by businesses that, in its opinion, fostered insecure work. They were casual employment, fixed-term employment, and the use of independent contractors. In terms of the first of those, fixed-term employment, in Labor's earlier Better Pay, Secure Jobs reforms, it had addressed this particular labour model. The solution under those reforms, as we know, was to limit the use of fixed-term contracts for the same role to a maximum duration of 2 years, subject to certain exemptions. Interestingly, one of those exemptions was where it was a government contract, so it was a matter of do as we say, not as we do. These reforms, of course, commenced late last year and restrict the use of fixed-term arrangements. The other models were dealt with through the closing loopholes reforms. That is, casual employment and independent contractors. Now, over many years, the union movement had targeted these labour models through the courts. The union's legal strategy would involve arguing that a worker engaged under a contract that described them as either a casual or a contractor was in practice a permanent employee. By finding at the court that they were a permanent employee rather than a casual or contractor as described in the contract, would provide a benefit such as leave entitlements that are to preserve permanent employees. The union movement's legal strategy had some significant success, and over many years there were a number of cases where there were findings that workers engaged as casuals or contractors were in fact permanent employees. In recent years, though, the High Court has delivered several decisions in relation to casual and contractor disputes that have provided primacy to the terms of the contract entered into by the parties. The High Court's decisions had effectively ended this very successful legal strategy for the union. Labor's reforms then target these 2 labour models and are a direct response to these High Court decisions. The approach to addressing these models is to make the following amendments to the Fair Work laws. Firstly, to introduce a definition of employee, and secondly, to amend the current definition of casual employee. And if I just address each of those definitions, the new definition of employee emphasises the real substance, practical reality and true nature of the relationship between a worker and the party that engages them to perform the work. In terms of casual employment, there was pre the reforms a definition of casual employment in the Fair Work laws. That is to be amended, effectively designed to achieve the same purpose. So a casual employee shall be an employee where the employment relationship is characterised by an absence of a firm, advanced commitment to continuing an indefinite work, and that the employee is entitled to a casual loading. The indicia for assessing whether there is a firm advanced commitment includes the following critical criteria, namely, again, consideration of the real substance, practical reality, and true nature of the employment relationship, noting that a firm advance commitment can be the form of a contract or a mutual understanding or expectation. These reforms, that is the introduction of definitions of employee and federal employee as we described, will commence in 2 months' time on the 26th of August. What these reforms mean is that in future disputes, courts will need to consider the terms of the contract, though this will no longer be provided with primacy because of the overriding need to consider reality of the work relationship. So the departure from the terms of the contract and looking at these two labour models in a different way means that businesses in the industry and outside will need to assess the practical realities of their work relationship to avoid improperly classifying workers in preparation for these reforms. Now this, of course, without doubt, creates a greater level of uncertainty for employers in terms of their work relationships. You can't simply point to a contract in the future and say that this describes a person as either a casual or contractor and that will be sufficient. It's clear from these new definitions that when a court is interpreted like they will in the future, whether or not a worker is a casual contract or a permanent employee, that they will go beyond the contract, which was certainly the position before the High Court decisions were handed down a couple of years ago. So we're really going back to the future, as it were. The other interesting change in this area has been a change in relation to casual conversion provisions. Now, under the existing provisions, an employer was required to offer to convert a casual employee to permanent employment in certain circumstances. That is, where they've been employed for 12 months. During the last 6 months of that employment, they worked according to a regular pattern of hours, and they would likely continue working these hours as a permanent employee without significant changes. Now, there were exemptions, basically the reasonable business grounds exemptions, which didn't require an offer to be made. Now, that was one possible pathway. The other pathway was that the employee could choose to request to convert to permanent employment in certain circumstances. Closing the loopholes replaces these existing casual conversion provisions, and no longer is an employer required to review their casual workforce and offer permanent employment. Now, this, it must be said, is a welcome development for employers because it was something that, in my experience, caused a great deal of angst, having to review a workforce and determine whether or not an offer needed to be made. In my experience, it wasn't a lot of take-up in that scenario in any event. And it's sensible, in my opinion, that the government's moved towards a employee choice framework, and that being the sole framework by which employees can convert from casual to permanent. So under this framework, casual employees may now give an employee written notification if they would like to change their employment status to permanent employment after 6 months of employment or 12 months for small businesses. In response, an employer is required to provide a written notification to the employee within 21 days, and there's a requirement to provide a certain form, content and notice requirements for this response to be properly provided by the employer. Again, an exemption similar to the reasonable business exemption applies. It's now for operational grounds that must be both reasonable and fair, and it'll be interesting to see what that term fair means in this concept. As I've said, the new employee choice pathway differs to the previous processes of casual conversion. It's the sole pathway, and it's certainly welcome. One of the other additional aspects of the reforms is that there's now a dispute mechanism where the parties don't agree. So the expectation is under the under the reforms is that there will be a discussion in the workplace if parties agree about the issue of conversion. However, if that does not successfully resolve the issue, an employee does now have the ability to refer that dispute to the Commission that has the powers to resolve the dispute, including through arbitration. That in practical sense means imposing a decision of the Commission upon the employer. The other related change under the reforms is some changes in relation to the casual employment information statement. Now, this is something that's part of the NES, has been part of the NES for some time. It was originally introduced and really directed towards permanent employees. It has been applied to casual employees for some time. Now, what the closing of loopholes reforms does in relation to the casual employment information statement is that it introduces an additional requirement in relation to the provision of that document to employees. So the current requirement, as we would know, is that technically you give the document to employees upon commencement. There's now additional requirements where the employer needs to provide the document after the employee has been employed by the employer for a period of 6 months or 12 months if they're a small business, and after each period of 12 months for which the employee is employed by the employer. Now, of course, these requirements dovetail into the changes in relation to the employee choice model for casual conversion. So really, in effect, what the government is seeking to do is that the document is provided to trigger consideration by the employee of an application for casual conversion. Hence the reason why there's an additional requirement that one be provided after 6 or 12 months of employment. That's the time at which, of course, employees can consider making such an application for casual conversion. Businesses will need to ensure they comply with these new obligations that again commence on the 26th of August this year. The other aspect that was the other model that Labor was seeking to target in its reforms is the regulation of labour hire. And this again has meant a very significant change in Australian workplaces. What's been introduced through the closing loopholes reforms is the implementation of the principle of same work, same pay for labour hire workers. And the reforms enable an application to be made, and it may be made by a number of parties, including the employee, a union, or even the host employer, seeking a same work, same pay order to the Commission. The Commission is prohibited from making such an order in certain situations, including where the work to be performed for the host employer is truly for the provision of a service rather than for the supply of labour. Now, that might be a situation, a simple example, where a law firm might be giving some advice to a third party. That situation would not be able to lead to a same work, same pay order. Where the Commission does make such an order, though, labour hire employees are required to be paid at least what they would receive under host employers' enterprise agreement. Now, in practice, the union movement has already used this mechanism very successfully, and particularly targeting the resources industry. And there's been a number of applications that they've made to the Commission, and in the end, in a number of situations, the labour hire firms to which the order directly tags have actually conceded on those applications. There is a separate application that has been made against BHP in relation to its labour hire workforce in the industry. That application is not by consent, and that application is current before the Commission to be dealt with. So it'll be interesting to see in that situation where it's not an agreed position as to what the principles are that the Commission is actually going to apply in relation to these sort of applications in the future. The other area where there's been some significant changes has been in the area of workplace compliance. Labor's closing loopholes reforms have made two significant changes in the area of remedies for non-compliance. That is, non-compliance with wage obligations under the Federal Rules. Firstly, the reforms have substantially increased civil penalties for existing contraventions that arise either from a non-payment or an underpayment of a monetary obligation. And secondly, introduced a new category of penalty related to the non-payment that arises from conduct that is deliberate. And this, of course, in the media has been described as wage theft. In terms of the higher penalties for existing contraventions, these are now different types of contravention, much like the approach that's been taken in relation to health and safety. So a general contravention, which is the least serious of any contravention, the penalties are to be increased $469,000 as a maximum, or 3 times the amount of the underpayment. For more serious contraventions, they attract a penalty of 10 times this amount. So it's really an eye-watering figure of $4.695 million, or again 3 times the amount of the underpayment. These higher penalties for general and serious contraventions have already commenced. Secondly, the third category of penalty for non-compliance, the most serious, of course, is the new penalty for wage theft. Now, wage theft became a national issue several years ago with a media frenzy following the revelation of the punishment of celebrity chef George Calambris, sorry if I've got that pronunciation wrong, for underpaying nearly $8 million by the Fair Work Ombudsman. The punishment, which was contained in an enforceable undertaking, involved the following: the imposition of an agreed fine of $200,000 and Calambris' agreement to doing some speaking engagements for the Fair Work Ombudsman. Everybody, including the Morrison coalition government at the time, agreed that the fine of $200,000 over the systematic underpayment of a workforce in the amount of nearly $8 million was light, to say the least. In response, some states, including Victoria, introduced wage theft laws that criminalised the non-payment of minimum employee entitlements. The Morrison government did seek to introduce wage theft laws, though these did not curiously pass federal parliament. The postscript to this story is that the Fair Work Ombudsman did not require Calambris for these speaking engagements that he agreed to do under the enforceable undertaking. In terms of the wage theft offence, it will apply in circumstances where employers intentionally engage in conduct that results in the non-payment or underpayment of safety net entitlements to their employees. So what this means in practice is that the offence doesn't apply to more generous employee entitlements under contract of employment. Now, the easiest example to give in relation to that is in relation to notice of employment. So we'd all know that there's a sliding scale for notice under the National Employment Standards, which maximises out at 5 weeks. Now, if a contractual entitlement in relation to notice under termination is a greater period of, say, 3 months, and an employee is terminated and the notice provided is 5 weeks, and there's a breach of the contract because the balance is not paid, that would not amount to a wage theft offence because the entitlement, the employee entitlement under the NES, has been provided for by the employer. In terms of the wage theft contraventions, they are the greater of $7.825 million, or 3 times the amount of the underpayment. And where there's been obviously a fairly significant media frenzy is in relation to the issue of director's liability. There's a secondary liability for an officer of the employer, and that's going to be achieved through the extension of provisions under the Federal Criminal Code. And if officers who then contravene the provisions face a jail sentence of up to 10 years. So in terms of where we're likely to be going for penalties, my expectation is, judging by the different maximum penalties under each of those categories, is that probably what the courts are going to establish is that principle around 3 times the amount of the underpayment. So, for instance, if the failure to pay an entitlement is in the amount of $1,000, then as a minimum you can expect that the penalty, the pecuniary penalty, failure to pay that employee entitlement is going to be $3,000 as a matter of principle. There might be exceptions that the court establishes in relation to that. However, my expectation is that really that 3 times the amount is going to be before the courts in relation to underpayments or non-payments of employee entitlements in the future. There are, as part of these reforms, some safe haven provisions. Now, these involve a pathway that's designed to encourage employers to self-disclose any conduct which may amount to wage theft to the Fair Work Ombudsman. Now, for small employers, the only pathway available is if they're able to demonstrate evidence of compliance with the Small Business Wage Compliance Code. And if they're able to do that, that's then a shield against criminal prosecution for wage theft. And secondly, there's a pathway for larger businesses that enables the Fair Work Ombudsman to enter into a cooperation agreement with a larger employer if they disclose that they've engaged in conduct that may amount to wage theft. Now, importantly, it's important to understand that these pathways don't prevent a situation where an employer or union seeks civil penalties for contraventions. This is only in relation to a shield against wage theft. So what that would mean in practice, if the state is an underpayment of $1,000, you might be able to go to the Fair Work Ombudsman with a shield against them taking action against you for wage theft. However, that of course doesn't prevent an employer or the union from taking proceedings against you seeking that amount, as well as the imposition of a civil penalty that they might seek to be paid to themselves or the union. Now, there's a bit of time. You've got a bit of time before these wage theft offences commence. They're due to commence on the 1st of January 2025. The other aspect that was introduced as part of Labor's closing loopholes reforms was the criminal offence of industrial manslaughter into the model Federal Work Health and Safety Act. And in response to that, all of the state Labor governments have updated their local Work Health and Safety Act to now include criminal offence of industrial manslaughter. Perhaps the issue that got the most amount of attention of all was this right to disconnect. Now, this has been introduced through the reforms. It was part of a last-minute deal with the Greens to actually support the reforms. And the right to disconnect has been inserted, or is to be inserted, in 2 different locations. So, firstly, there's going to be a general right to disconnect under the Fair Work laws. And secondly, there's going to be a model right to disconnect that'll be introduced into modern awards. In each case, the right to disconnect shall entitle an employee to refuse to monitor, read, or respond to contact from an employer or third party, think client, outside of the employee's working hours unless the refusal is unreasonable. Now, it's important to remember that this will act as a right rather than a requirement, meaning that an employee can choose whether to respond or connect out of hours if they wish. A critical aspect of the right to connect is, of course, whether the refusal to connect is unreasonable. Similar to the criteria for reasonable additional hours, that is a requirement to work more than 38 hours per week, already contained in the Fair Work laws, whether a refusal to respond is unreasonable will be determined by a multi-factor test, and that includes an assessment of the reason for the contact, the method of the contact, the nature of the employee's role and their level of responsibility, their personal circumstances, and this to me is the most critical of them all, the extent the employee is compensated to remain available during these out of hours. And that, to me, is going to be the most critical issue for the future. The model right to disconnect term hasn't been agreed upon at this stage, or a decision hasn't been issued by the Commission in relation to the form of that. But certainly the discussion that's taken place before the Commission to date in relation to that issue has made clear that this right, of course, dovetails into other issues, such as whether or not an employee is paid an on-call allowance and what the remuneration might be if they're called in when they're on that on-call. So it seems to me logically that employers will need to review their contracts of employment to consider this issue, and where there is a need for employees to be on call and called in or to work outside of hours, that their remuneration be recognised by that in some way. And that seems to be the most logical way to do it, where it's absolutely critical or essential that employees are needed to be contacted out of hours, whether that be for a short period or called back into work for whatever reason. The obvious situation for that is for those doctors, for instance, or other health professionals having to be called in to deliver a child. That's obviously a situation where you need to have an on-call roster of payments where people are called in to work in that situation. Again, much like the casual conversion issue, there's an ability for a dispute to be referred to the Commission in relation to the right to disconnect. Again, the expectation is that the issue is attempted to be resolved in the workplace, and failing that it can be then referred to the Commission, who can then make orders in relation to the right to disconnect. These reforms, again, much like the others, are commencing on the 26th of August 2024. So it seems to me, as you're reviewing your contracts, if you do that normally at the end of the financial year, that might be an issue for some groups that you might want to consider. In terms of some of the other issues, certainly in the aged care industry, my experience of dealing with my clients is that labour shortages remain a challenge, and that's despite the work value decisions that have been handed down, which have, of course, have increased the minimum pay that applies in the industry, and of course there's more to come. On the general workplace issues front, we've of course recently had the federal annual wage review that's been handed down. Now that is leading a general increase of 3.75%, which increases the minimum hourly rate, the national minimum hourly rate, to $24.10, and a weekly rate of $915.91. Now this, in fairness, is probably lower than expected given where inflation is at the moment. Most stakeholders felt that it would be around about the 4% mark. So 3.75% is probably slightly lower than expectations. The other issue that comes out of the work value comes out of the annual wage review. Now, this is only the second decision, that is the annual wage review decision, where the Commission has had to consider the new objectives in relation to gender disparity. What they did in last year's review is they foreshadowed a two-stage research project to further investigate gender wage disparity consistent with that new objective at the time. Now what's happened is that the research project has identified some priority areas where it was felt that there was greater gender undervaluation that include disability workers covered by the SHADS Modern Award. And to take action to address this, the Commission will initiate proceedings to review whether rates of pay should be adjusted in these priority areas to remedy gender undervaluation. Screen has just frozen there, but I was just going to talk about the future. Touching upon some issues that we've seen and that employers are facing in the industry and elsewhere. So, in terms of the issue of bespoke work, there was a report from the CSIRO back in 2016 into digitally enabled workforce, and it noted the following changes occurring in Australia through the place: increased technological change, rapid growth of the freelance employment market, home working facilities, and working from home. Of course, these trends have only been enhanced by COVID. Over 4.3 million of Australia's 13 million workforce were working from home in March 2021 during the COVID era. Over half of all workers in the finance industry and public administration were working from home at that time, which is a staggering amount. Industries have obviously increased their use of technology, and workers across the country have, during that period, established home offices, providing a boom for companies like Officeworks. In a number of workplaces, workers have enjoyed these developments and wish to continue to work remotely where they can. Employers are, with the current labour shortages, having to accommodate this desire of workers. Bespoke work is likely to continue. Working from home, which can be sought under current flexibility arrangements under the Fair Work laws, is currently being discussed as a possible future workplace right. And Senator Pocock, who was the Greens senator who pushed for the right to disconnect as part of the closing the loopholes reforms, is also pushing for a 4-day working week. Now, of course, in terms of our industry, working from home is not realistic for our employees, our operational employees, but certainly for our administration staff. They may see their colleagues in the industry and elsewhere seeking working from home, and that may well be an application that we face from time to time. In terms of flexibility, employers would be forgiven for thinking that the reform, including the closing loopholes reforms, provide flexibility in one direction. New South Wales Business Chamber has proposed a new flexible ongoing employee for retail and hospitality workers that would involve paying part-time workers more to be rostered at their employer's discretion. Under the proposal, part-time workers who otherwise work set rosters could agree to a 10% loading in return for their employer rostering them when it wished during their ordinary working hours. Now, of course, those of you familiar with part-time work would know that that would avoid the normal approach, which is the requirement to pay overtime when they work outside of their set rosters. So it was an interesting idea that was brought up with by the New South Wales Chamber in circumstances where there was a discussion about the need for employers to have flexibility, not just workers. I'm going to finish in relation to test cases. It'll be interesting to see what wage theft and higher penalties test cases come out in the coming months. But certainly in relation to those, as I've described, I think where the courts will go in relation to those new penalties is that principle of 1:3. So by way of summary, the Labor Party's industrial relations reforms are the most significant reforms in over a decade. Aims such as increasing wages and gender equity are well-meaning. The non-stated aim, though, in my view, is to seek to provide greater relevance to the trade union movement through changes to enterprise bargaining rules and union representation rights. It remains to be seen whether these well-meaning aims achieve their goal or simply impose more red tape for employers. Certainly in the area of gender equity, that's where, in my view, some real gains have been made that should be applauded. The others seem to impose costs for employers, in particular for compliance mistakes, many of which are mistakes rather than deliberate conduct. But for employers, the time is right, in my view, to review contracts, policies and practices to ensure compliance with these reforms, many of which are going to be commencing in 2 months' time. So that's my seminar for today. Thank you very much for those who came in. Michael, I think, has indicated that we have some questions.
Yeah, just a couple of questions from the online stream, mate. Where does the manager position description fit in regards to the right to disconnect when they're expected to be available for after-hours contact for everything without a call allowance?
Sure. Well, I think there are two categories, broadly, there's two categories of employees, those who might be part of management and those who are operational employees. In the category of managers, certainly those that are being remunerated handsomely, there's nothing wrong with an expectation that there would be some level of out-of-hours contact despite the right to disconnect. However, obviously with the right of disconnect due to commence in a couple of months' time, it would be appropriate to review the contract of employment. Now, generally, contracts of employment for managers would say something like this remuneration is paid for all hours of work and there's an expectation of some out-of-hours work. But if it doesn't say something like that, which addresses the right to disconnect, it would be appropriate to review the contract to ensure that the response to the right to disconnect. And that way, in my view, you comply with the criteria that's set out in relation to whether it's unreasonable not to connect. And certainly in that situation where there are appropriate contract terms, the employee can certainly take that position. The manager did not respond to contact outside of hours.
And just the last question, where does the right to disconnect fit in with contacting staff to pick up vacant shifts? Sure, what they mean by that is maybe someone calls in sick and can't come in, and so you've got to call someone else to.
Sure. That, in my view, is not a straightforward issue. And I think it would depend on really the employee's response to that. Generally speaking, you would expect most employees will respond to that situation. So if you take another situation where you might have a workforce of casual employees, the fact of the matter is, in terms of contacting about shifts, shifts where both work. The reality is that you're going to do that outside of work hours, so to speak. And you would expect in the ordinary course that the employee would respond to that. Of course, if they don't, you're going to be able to do the shift. But that's sort of there's a level of that contact that's really strong and seen. So I don't see that sort of contact changing. And it seems to me it's bordering on unreasonable if you're not responding to that sort of question.
I'm sorry, to say something outside of the scope of the right to disconnect is in relation to can you attend to this task, which is part of your role, where I think that's are you available to work is not really.
I think that's right. I mean, I think that's part of the consideration about whether it's unreasonable not to connect in that situation. I think what's relevant about that too is that, as you said, it's not asking you to do any work. It's a quick response, as it were. Are you available? It's yes or no response. It seems to me, unless there's some good reason, it would be unreasonable for you not to respond to that query. The next question might be, is there an expectation that you do accept that shift? Now, that's a different matter. And there might be a whole lot of reasons as to why you might not be able to accept the shift in response to that query, for instance, family responsibilities. And that would, of course, be reasonable.